What's going on, guys? I'm Steve. Welcome back to the channel. Welcome back to another video. If it's your first time stopping by the channel, hit that subscribe button. Trust me, you won't regret it. You're a returning subscriber. As always, guys, welcome back, and I do appreciate support. Guys, I got some news out of Kissimmee, Florida. Shout out Kissimmee concerning the Stephan Stearns trial, upcoming trial, for the assault or in violation, if you will, of 13-year-old Madeline Soto, who died last year, early 2024. Now, this guy's SA trial is coming up in the next couple weeks, which I plan to attend and take you, the DRC family, with me, you know, and provide coverage from down there. And today, him and his lawyer was in court in a last-ditch effort to suppress some evidence, because they have a motion suppression of evidence hearing tomorrow. And the motion was denied today. The reasoning they gave this is strange to me, but it is what it is. Now, he's set tomorrow to go before the same judge you're about to see in this video concerning his suppression evidence hearing, because his lawyer said some crazy stuff in court and didn't give a valid reason why. This case gets stranger and stranger. But one thing's for sure, this guy right here is going to the gallows whether he wants to or not. It ain't no way he getting out of this, no matter how many different hooks and ladders he tries to throw into the equation to divert the train that's coming of justice, if that's what you want to call it.
Key evidence is at stake in the case surrounding the murder of 13-year-old Madeline Soto. Stephan Stearns is trying to get much of the evidence against him tossed out. Watch News' Bob Hazen is at the courthouse where Stearns is expected to be in a few hours.
This is a crucial moment for his defense because those videos that were allegedly found on his cell phone are the reason why he was arrested in the first place. This is the second day in a row that Stephan Stearns will be in court. He was the boyfriend of Madeline Soto's mother, and police say he killed Maddie last year, a day after her 13th birthday party. Investigators focused on Stearns early after allegedly finding videos on his phone showing him raping the girl for years, and that is the evidence that his lawyers will be trying to suppress today. They say investigators took his phone unlawfully and violated Stearns' rights against unreasonable searches. But yesterday, Stearns' lawyer tried to get this hearing delayed, claiming that they had new confidential information that could affect the case. His lawyer would not explain what that information is.
Defense is coming to information that at this time the defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge.
The judge denied that request to postpone today's hearing, and we are expecting several witnesses to testify today. That hearing could last several hours. All of this is in the case dealing with Stearns' alleged sexual abuse of Maddie, and he's facing a murder charge in a separate case. But of course, these are intertwined, especially because if he is found guilty in that sexual abuse case, prosecutors plan to use that conviction in his murder case to argue that he deserves the death penalty. Covering Osceola County in Kissimmee, Bob Hazen, West 2 News.
That's the story today of America's favorite goofball, Stephan Stearns. Now, a couple of things I didn't realize. I didn't know he had a public defender. I thought he had a paid lawyer. He got a public defender. That makes it even worse. You definitely getting screwed, dude. Now, if we look back a little bit, a couple months back, they tried, his lawyer put out a motion to try to have the trial be without the media in it. That was denied. So it's going to be media in there, you know, and it's a trial that, you know, his dirty laundry is going to be aired. Now, look at now what they say. Oh, let's push this motion back. Now, I got this from the court room camera, which I'll show you in a second, the full court thing. This is what the motion was for. They said they had a secret witness not yet verified, or they couldn't disclose it, pending if this is valid or not. Why would you even bring that up? You know he was going to ask who the witness, and you say no. You know they're going to tell you no. You can't do it. So it was a waste of time even doing that. They look stupid doing that. Now, Then they also say it's not enough time with the pending death penalty case coming up. Those are two separate trials. One is for the death and one is for the assault of this girl, the violation, which is coming up in the next 2 weeks. So we ain't had enough time to work on that other. They ain't got nothing to do with it. You'll have enough time. Make him your only client and then you can work on that. This guy right here is dog shit. He don't deserve nothing. You see he got his hair cut now? And I'm gonna tell you something, those that been locked up, no, that's one of the worst haircuts you could have as a white male going in there with the crimes you got. It is. It's one of the worst. This guy's stupid. You know what I'm saying? He's trash. He need to go. Now, a lot of people putting up, saying, you know, we don't know if the mom, Jen Soto, knew about it and all this other stuff. That'll come out later on. And I think I got a theory to this whole situation with this murder case, but I'll speak on that on another time. And I mean, I think this right here might be the monkey wrench in the plans of what they're talking about. But I don't want to say nothing right now because it doesn't make sense for this assault case. This guy has hundreds, maybe even thousands of video and photos of him violating a child. It don't get no worse than that. If you really pay attention to this whole thing, ladies and gentlemen, his dirty laundry is aired, but he doesn't want it to where the videos or the photos are shown in the courtroom. Why? Because family and friends that befriended him through his relationship with Jen Soto, he don't want that to be seen. And that's the thing. People do some of the same shamelessest shit out here. And they don't want their shame exposed, even though they expose it themselves via pictures and all this stuff. He took pictures and kept them for years of him doing this to a girl in the house. What you think about that shit? This guy ain't give a damn about nothing. He carried trophies of photographs and videos of his conquest of a child in his phone, like it was a badge of honor. He had a hard drive full of stuff. How sick is that? And I think him taking all them pictures and keeping them, that wasn't just for his own personal value. And I'm being dead honest. I think he was doing something with them photos. I think he was doing something with them photos, whether it was dark web or whatever. That's just my opinion. But either way, man, trash like this got to go. In closing, let me show you the 12-minute video, and I'm in court, and the lawyer looking crazy, and him sitting there looking stupid as all hell. See you in the next video. Take care.
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
Alicia Smith and Alice Johnson on behalf of Mrs. Stephan Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has case law provided a copy to the state already. I'm going to give you a moment to read, Judge, or are you going to read?
Just a moment. These highlight the McKay factors.
Essentially, Judge, they are essentially stand for the same
Go with the McKay factors. Thank you.
And the cases that I provided to the court are both from the state, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay versus State, first DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025 Westlaw 1119091 from last week, from April of 2025. Shokola versus State, 867 Southern 2nd 129 50 CA from 2004, and Singer versus State, 286 Southern 3rd 343 of 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion, as well as in preparing the other case for trial. Defense is coming to information that at this time the defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of the homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would be moving to continue the regular pretrial, even aside from the motion to suppress hearing, because we did an evidence viewing. We weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing both from factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing a motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense would be able to disclose that information even to the court, even if the ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed, discovery exhibits haven't been disclosed in regards to it, because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there's been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March. 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you.